I'm going to make this short. This is Ken Hauer, president of the Rubicon Trail Foundation. At the June Rubicon Information Group, or RIG meeting, we had Jesse Barton, our attorney, do an RS2477 presentation. The Rubicon Trail, as some of you who have watched my other videos know, that it's not a county road. It is a public road that falls under RS2477 rights, or revised statute 2477 back from the 1800s. So this presentation by Jesse is to talk about that and what moving the trail or any reroutes, what that might possibly mean. So go ahead and enjoy the presentation. Thanks so much.
Let's see.
All right, so you've got it on the screen there.
Yeah.
Everybody can see it?
Yep.
Mm-hmm.
Yep.
All right. So thank you, everybody. As Tyler indicated, and Ken, my name is Jesse Barton. I've done the legal work for the Rubicon Trail Foundation for approaching 15 years now. They had a fair amount of experience with RS2477. I do not profess to be an expert at it, but I've been looking at it on behalf of RTF as well as other off-road groups over the years because of my experience with RTF. And so I do consider, I've read a lot of cases. I've read a lot of law on this particular statute. And so over the course of the past several years, I do feel confident speaking about it, but not necessarily an expert. And let's see, one thing that is not on the first slide there, Ken, is the California State Bar would very much like me to state right now that this is legal information, not legal advice. And so we are not entering into a attorney-client relationship by me providing this information. All right, so we are now on slide 2. Thank you, Ken. The origin of RS2477 came about when the United States was expanding its territories west and acquiring new lands. Congress wanted to encourage the settlement of those lands. And one of the many laws that it passed in 1866 was revised statute RS2477. And what it allowed was that if somebody wanted to cross unreserved public domain lands and build a road, whether it be a wagon road or a horse trail, they were authorized to do so. And as those roads or trails became used by the public, those would essentially become public right-of-ways. All right, we didn't have asphalt or anything like that, but they wanted the Congress wanted to encourage the settlement of lands, and they didn't want trespassing or anything like that to be a hindrance to the settlement of these lands. And so they authorized the development, construction, use of these roads throughout the West to provide public access. And then 110 years later, it was repealed in 1976. And the statute, until it was repealed, the statute provided the right-of-way for the construction of highways over public lands not reserved for public use is hereby granted. It's a very short statute, obviously. I wish that our legislatures today could adopt laws this easy to read, but we're not so benefited, I guess. So that's how it stood for 110 years. And although it's nice and short and succinct, there's no real details or guidance on how to establish such a right-of-way. And so what has happened is over the past 110, or even more than 110 years, because although it was repealed in 1976, litigation continues over RS2477 routes. And the guidance has essentially developed through case law. And that makes it very difficult to follow because you have to, United States is a very large country. There are cases in Colorado. There are cases in Alaska. There are cases in California. And all of the courts approach it somewhat slightly differently. And so there is no uniform rule that interprets everything about RS2477, okay? When Congress did repeal it in 1976, it preserved any valid right-of-way existing on the date of the repeal. And so that means any road or right-of-way that existed prior to 1976 was not threatened or undermined by the repeal in 1976. And I'll go into more detail on that in slide number 3, Ken. All right. Thank you, Ken. What does it take to establish an RS2477 claim? The way the courts have interpreted RS247 is an offer of dedication by the federal government that can be accepted by the public or a local government. And it's very important, the public or a local government. The dedication is often described as a conveyance of private land, either in fee simple or as an easement for public use. Dedication is a very important aspect of current law. It happens every day throughout this country. And the most common form of dedication, and I think everybody can relate to, is when a developer wants to build a subdivision of homes in some field, in what is now a field, and he wants to develop a subdivision of 100 homes or 100 condominiums or whatever it is. What that subdivider will do, what that developer will do as part of the subdivision map, is he will lay out the routes for the streets, he will lay out the routes for the utilities, for the sewer lines, for the electrical lines, and then when he records the subdivision map with the county, he dedicates the location of the roads, the easements for the utilities, the easements for the sewer lines, the easements for the water lines. He dedicates those to the county. And then the county can take a look at this subdivision map and they can accept the offer of dedication made by the developer. And once accepted by the county, those essentially become the county's easements and right-of-ways. Okay, there are ways around it, but for the purposes of today's discussion, once accepted by the county, those easements and right-of-ways become property of the county for public use. And that's why the county will come in and you know, if it's in an area that receives snow, they'll plow it, they'll reapply asphalt, whatever the case may be. Now, how can an RS2477 route be accepted? It can occur through the long-established public use of a road and not necessarily a highway, although RS2477 says a highway. Don't think of a 4-lane highway or a 6-lane like Interstate 80. It could be a trail, okay? But long-established public use is one way to accept the offer of dedication. A local government explicitly accepting the offer of dedication, which is what happened in the Rubicon Trail situation when the County of El Dorado accepted the Rubicon Trail as a public road. The third way to accept an RS2477 route is public maintenance or improvements made to the road, which shows a demonstration of or an expenditure of public funds on the improvement, construction, operation, and maintenance of that road. And paperwork is not necessarily required. You know, if you look at that first bullet point, you know, an offer can be accepted simply by people using the road over a period of time. You don't need to fill out a particular piece of paper, record it with the county, or anything like that. That would be helpful if those things occurred, but it's not necessary. When can the offer be accepted? And this is very important. I get a lot of questions about this. The offer has to be accepted prior to the land being removed from the public domain. And there's a lot of confusion about this. And so what I added here is, for example, patented or added to federal reserved lands. When this country was settling lands, it was public domain lands. They were owned by the federal government. But if you wanted to acquire those lands from the federal government, you would essentially establish a homestead. You would mark out your territory. You could clear the land, grow agriculture, build a home on it, whatever you wanted. But to demonstrate that you want that property, you had to exercise some control over it and obtain a patent from the government. And once you did that, it became your property. I forget what they sold a patent for, $10 or something like that. Depends on the year. But the land had to be in the public domain. This does not mean national forest lands. That national forest lands are reserved federal lands. And so the route has to be established before the federal government either patented the land to a private person or added them to federal reserve lands, national parks, Forest Service doesn't, or forest lands, a national forest. So it has to be in the public domain. Next slide, Ken. All right, so there are two deadlines as to when. The RS2477 rights-of-way must be established prior to 1976, the repeal of the revised statute 2477, and the RS2477 rights-of-way must be established prior to the land being removed from the public domain. Example, land patents obtained under the Homestead Act. And this is important because this is different throughout the country. So, as an example, homesteading in California ended about 1950, 1960. I didn't, generally the last patents in California for public domain land were issued right around 1950, 1960. The Homestead Act was repealed in 1976. However, homesteading in Alaska ended in 1986. And then Alaska is a very special case. The RS2477, you couldn't get a RS2477 route in Alaska after 1969. And so it depends on where you are, but ultimately the deadlines, it has to be the earlier of the two. It either has to be prior to 1976 and or it has to be prior to the land being removed from the public domain. And these are very important aspects. A lot of people mix these up or confuse them or conflate them. It has to, you have to get it, that route has to have been established before it was removed from the public domain. And I'll stop there. There's a lot of people on this call. If folks want to raise their hand while I'm presenting, that's fine. I just don't want people interrupting. I don't want 10 people interrupting while I'm speaking. It would be very difficult to manage that. But if folks want to raise their hand, if I say something that they want to talk about, please raise your hand. I'll address it, or we can wait to the very end of the presentation. So Ken, slide 5, please. What type of interest is conveyed under RS2477? It's a right-of-way for a public highway. It's a road. It's equivalent to an easement. It's not a fee interest. And so by fee interest, if folks are unfamiliar, fee interest means you own the dirt. You don't own the dirt. You own a right to travel over the dirt is what you obtain under RS2477. It's simply a right-of-way. You don't own the road. You don't own the dirt. You essentially own simply a right to pass over someone else's dirt. Okay, next slide, Ken. Who holds the rights under RS2477? Who has legal standing? And this is complicated. The answer depends upon who the rights are being asserted against, the types of rights being asserted, and the causes of action being asserted. It's a highly fact-sensitive analysis. What I have attempted to do here is summarize generally California law in this respect, because as I mentioned previously, there are, this is a large country and different courts have interpreted RS2477 differently. There's different law in Alaska, for example, but here in California, there are two primary cases regarding who has rights under RS2477. First one was in 2007, Friends of Panamint Valley versus Kempthorne. the Panamint Valley Trail. If anybody has ever been lucky enough to be on that trail, it's a wonderful trail. It was shut down a couple of decades ago. That court, and this is important, this is a district court, Eastern District Court of California in 2007. RS2477 rights in public highways vest in the local or state authorities who manage them. Because what happened in Panamint Valley was the off-road club had acquired mining rights that they asserted they had a right to access using the Panamint Valley Trail. And the court shut them down there. The court said, no, you didn't have adequate standing. A mining right is not adequate to allege an adequate right under RS2477 to, it was essentially a quiet title claim. And it wasn't enough to establish a right to assert a 2477 claim. And so Friends of Panamint Valley, they lost that case. The next case was 7 years later now, and this was in a superior, not a superior, this was a, it was in the Ninth Circuit, which is a senior court to a district court. It's above the district court. And this was Mills versus United States. And in the Ninth Circuit, the court held that prudential standing allows a private owner to assert RS2477 rights against anyone, including the federal government. And what's interesting, you know, these sorts of things, I could talk about these for hours, but unfortunately, the Ninth Circuit never even brought up Friends of Panamint Valley in its decision, which is frustrating. It would have liked, because they spent pages discussing standing, and they never even discussed Friends of Panamint Valley and how that case fits into their analysis of prudential standing. Courts do it all the time. They punt on issues that are not directly in front of them. And so my opinion is they punted on this one. But nevertheless, under Mills, a limited form of standing exists that allows a private landowner to assert RS2477 rights against anyone. And so this is why this is such a fact-sensitive analysis, and why RS2477, I was initially reluctant when Ken asked me to do this, because I don't want to give the impression to anybody here today or who may be watching this video that RS2477, you can reduce its qualities, or you can reduce its analysis to a couple of checkboxes. You just can't. It's far too subjective, far too detailed, and it's complicated. And so all I can give you are, unfortunately, generalities, but that's simply how the law works. Next slide, Ken. How to preserve an RS2477 right away. This comes up a lot on the Rubicon and elsewhere. Constant and regular use. There is no strict formula on what constitutes adequate use to maintain RS2477 rights. It could be once a month. I think it needs to be more than once a year. But, you know, there is no case that says, you know, once a month is enough, once a year is not. That's such a narrow situation that it's probably never going to arise. But as long as the public uses the route and has used the route for a period of time and it is passable, I think that that is enough to establish constant and regular use. What about relocation? This comes up a lot. Can an RS2477 right-of-way be relocated without risk of losing its status? In most cases, yes. And I cited two cases here. One in California, the Western Aggregates case, and then one in Colorado. Both of these, of the two, the Western Aggregates case is the more detailed and thoughtful analysis. You know, in that case, what happened in Western Aggregates, it was in the county of Yuba. And if folks are familiar with Yuba and the gold fields, the Yuba River, upstream of the Yuba River, it was subject to significant hydraulic mining. And over a period of a couple of decades, just mountainsides were washed away in the search for gold. And these mountainsides washed down the Yuba River and were deposited in the valley and created what is now referred to as the Yuba Goldfields. And as this soil was deposited in the valley of around Yuba City and Marysville, there were routes in that area that people used to access their lands, perhaps mine their own gold. And it was an argument over one of these very old routes on whether or not it was still in existence, because the route had changed so much, because so much silt and soil had been deposited over the original trail route. And ultimately the court agreed that yes, it didn't matter. As long as the route was continued and used throughout the period, never given up, and people continued to use it in a regular and notorious manner. The court said, despite it being moved to slightly different locations, the route was still valid. And so it's a very strong case. The next one is, what happens if you don't use a route? In most cases, non-use by itself would not result in the loss of RS2477 rights. This was also discussed in Western Ag. The reason for this is that, going back to my second slide, I stated that what kind of right-of-way do you acquire in RS2477? An easement. An easement lasts forever, whether you use it or not. An easement is a right to use somebody else's property. The only way you lose an easement, I mean, there are several ways, but the legal way to terminate an easement, it has to be a quiet title action. You have to clear title. If you have an easement on your property and somebody stops using it, and you want to terminate that easement, you're going to have to go into court and you're going to have to file a quiet title action to terminate any rights that the easement may hold in the future. And so in most cases, non-use by itself would not result in the loss of an easement right, which is a 2477 right. Okay, abandonment. Generally, formal abandonment procedures will result in a loss of RS2477. Just like I said, how you terminate an easement is through a quiet title action. Each county has its own formal abandonment procedures for routes, roads, highways, and they generally have to go through that abandonment process in order to terminate an RS2477 route. What about gates? This one I get calls on every so often. Physical structures can prohibit access can result if continued for 12 or more years. Because this is a federal right, that is a statute of limitations period. So if somebody puts up a gate for 12 or more years, you can lose an RS2477 route. They can file a quiet title action and clear title. What about permits and fees? Does that terminate a RS2477 right away? No, generally not. The federal government can require that a permit be issued to utilize a 2477 right. This was established in United States versus Volger, which was a Ninth Circuit case. And generally, the federal government can charge fees to even utilize RS2477 rights away, but only if there is a congressional authority to do so, which is not always present. That was a primary issue in the Wilkinson case. And government just can't charge fees. There are in order to charge fees to access public lands, even a park or a national forest, there has to be specific authority for it. And that's outside of RS2477. But just because they charge you a fee does not mean you're going to lose your right of way. I don't see any hands up. Okay, next slide, Ken. Federal scope of authority over an RS2477 right of way. These rights of way are subject to regulation by the relevant federal land management agencies, and that's important because you have to figure out which land management agency the RS2477 right of way, who manages that land. Is it the Park Service? Is it the National Forest? Is it the BLM? Is it the Army Corps of Engineers? You know, there's a plethora of federal agencies, and you have to figure out which is the right one. And all of them have the authority to regulate the use of that route. It's been established in the cases that the regulation must be reasonable. And then, what often comes up is if the route needs maintenance, you need to consult with the federal agency to make sure that the maintenance doesn't impair their values, whether it's habitat or sensitive species. And then they may be able to charge you permits and fees as part of that regulation to exercise their authority over that right of way, but they cannot prohibit access. No hands up. Okay, next slide. I think we're getting close to the end here. We are. As I mentioned at the outset, it's highly complicated. No element of it is susceptible to hard and fast rules. You've got to be very careful. I get people who call me on the phone and they give me this question, well, Jesse, tell me, what do I need? What are the check boxes that I need to, what are the facts that I need to establish? It's variable. It's variable. There's no list that universally applies throughout the United States. It depends, and it could take a half an hour to an hour going over some of these facts, and even then it may not be entirely clear. It's highly fact specific and sometimes subjective. And you speak to one lawyer and he'll give you one opinion, and then you go into court and the judge may disagree. And so it's very subjective. It can be very subjective. There are numerous RS2477 claims exist, and it can take years and significant sums of money to resolve. May be discouraging to folks, but that is the fact of the matter. It's just, I wish it was easier. I genuinely wish it was easier, but if it was easier, maybe that wouldn't benefit us, people who like to use these routes. So perhaps it's better that it is difficult. And so I'll stop talking. I am happy to answer any questions. Thank you. I see one hand up. Pierce.
Shocker. Yeah. Hey, Jesse, how are you? Thank you so much, by the way, for doing all that legwork on this. This is tremendously informative, and I appreciate, although you say you're not an expert, it sounds like you are tremendously knowledgeable in this. So I think it'd be beneficial. I guess a couple of questions I have for you. The big discussion over the last few weeks has obviously been this reroute and the preservation of the RS2477 and how that is preserved if this reroute is there. You mentioned a few things that are obviously concerning to all users. It should be. Is one, you mentioned abandonment. And that is clearly stated in this, this grant that this section of trail would be abandoned. And you made it very clear that that will result in the forfeiture of the RS2477. The other piece to this is Placer County, to my knowledge, as you mentioned, has not gone through the formal abandonment of this route section that is currently there. So, in your opinion, I know you're not representing anybody here, but in your opinion, I guess why at the end of the day, or give us your thoughts on this reroute, and what are the protections that we're all asking for? And this question will default to Joe Chavez a little bit here. Why is there not a guarantee on this section? I think everybody said this, from myself to Tim Green to some of the owners in there. We wouldn't be against this if there was guaranteed protections over this. It was also made very clear to all of the people on other phone calls that the Tahoe National Forest would have jurisdictional authority over that reroute. And so help us understand a little bit of those things that would guarantee those protections, particularly when some of the language that you just used that is in the grant would formally abandon the RS2477 route.
Okay, yeah, thank you. Thank you, Pierce. Try to unpack that. There was a lot in there.
Sorry.
Yeah. As far as the Tahoe National Forest having authority over the reroute, you have that currently. As I mentioned in that previous slide, the relevant or the regulating federal authority does have the ability to regulate access even over an RS2477 claim. So that is currently in existence. And as far as the reroute, I would like to see the formal abandonment papers that you have referenced. I'd like to take a look at those, but just by moving the route by itself, based on those cases that I just listed, I am not terribly concerned that the RS2477 rights are going to be lost, as long as there is a recognition that this is a reroute for the purposes of safety and environmental protection. It's simply necessary. I think that tracks very nicely with the Western Aggregates case. But if there's some specific documentation available that outlines what Placer County is going to do and how they're going to do it, I'd like to see it. I hope that helps, Pierce.
Yeah, and just to be clear, I think there might be some confusion. Placer County, to my knowledge, has not formally abandoned their rights to this route. And I guess my question is, you mentioned earlier on that they would have to go through a formal abandonment process, which they haven't, but in this grant, and I think what scares a lot of us is that there is, language in this grant that says they will you guys will formally abandon this route. And I'm just wondering how RTF is supporting any of this grant with that type of language in there, when you just clearly stated that a formal abandonment would lose the right. You said it would absolutely result in the right of the loss of that RS2477. So I'm just wondering that your position, your legal counsel, how are you supporting any of this grant right now with those very strong terms in this grant?
Not again, but I'll state it here. RS2477 is not susceptible to strict rules and interpretations. And so without a formal abandonment, with nothing else, then perhaps that needs to be looked at. But if what we're talking about is an abandonment, but at the same time there's a recognition that there is no abandonment of the rights associated with the route, then I'm not concerned with the loss of the old route. I'm simply not. If there is a transfer, a knowledgeable or an explicit transfer of the rights from Route A to Route B, I'm not concerned with that. I would not be concerned with that.
I have a question, Jesse.
That helps. Oh, John, go ahead.
So it's a follow-up to Pierce's question. I think this is where some of the confusion lies. And correct me if I'm wrong, whomever. Formal abandonment would be a specific process undertaken by the county of Placer to say we are abandoning this RS2477, right? Something like resolution signed by the board of supervisors.
Yes, public hearings, yes.
And
yeah.
With public hearings and notices. It wouldn't be, sorry about that. It wouldn't be them simply moving the trail from one spot to another, or anybody moving the trail from one spot. It has to be the board of supervisors saying we are abandoning this.
Yeah, but even then, John, as I stated to Pierce, if there's a recognition that, okay, we're abandoning the location, but we are not abandoning the pre-established rights were established under RS2477, we're picking them up and moving them from point A to point B. I'm not concerned if there is an explicit recognition of that. No.
Okay.
To Jesse, as an attorney, I review contracts all day long with attorneys for big things. And, you, as I'm sure you'd represent from some of your clients, if you had a client that said, hey, we need a guarantee that you're paying child support, doing these things, you as an attorney would write some pretty strong language in that agreement to ensure your clients would be guaranteed a specific outcome. Why is this different? Why is this different that we can't have Placer County and Forest Service come to the table and guarantee this reroute staying open? Like, I just don't understand the stall tactics from the Forest Service in this and the county to say, you know what, we recognize this route. We're willing to put it on paper. We think the reroute is so important for the ecological piece of this trail not to be degraded through multiple use. We want to see that other area preserved. And because we're so interested in the environmental sensitivity of this, we want to move it. And in order to get the public support on this, we will ensure that if this is rerouted, we won't shut it down. And I guess the question is, why are we seeing any stall tactics at this point from any government agencies to guarantee that? Because if that were the case, you would get the full support, I know, of myself and a lot of other user groups and owner groups to say, if that's what's on the table, then we'd all support this. And I think, you would guarantee that. You would want that for your clients at the end, not just RTF, but, any other clients to say, we need something in writing that says this won't be kind of forgotten or forgiven. I guess what's the process moving forward to try to attain that? And Joe Chavez, this kind of goes to you a little bit. What's the process for you guys to give those type of guarantees to the community to ensure that the reroute kind of falls under that same pretense?
All right.
Yeah.
So what I can say is that Matt Jedra, the acting forest supervisor, Tahoe National Forest, in the grant final application did submit a letter of assurance to the OHV division, basically stating that the Rubicon Trail will stay open and open year round, and that the intent of this reroute was to ensure its continued viability or connectivity. And we've said that before, so now it's in a letter from Matt Jedra. I don't know that the participants here, the partners, fully accept that, but he did submit that as part of the grant final application.
And let me address something as well, Pierce. You mentioned guarantee numerous times, and I will tell you exactly what I tell my clients when they approach me and they say, Jesse, we want a guarantee. And I tell them there are only two guarantees in life: death and taxes. That's the only thing I can guarantee you. And in fact, and I'll even add a third: arguments with your spouse. That's another guarantee. But other than those three, I cannot guarantee anything in a court of law. It just doesn't exist. It doesn't exist, unfortunately. You can provide, I could do everything I can to put my client in the best position possible, but ultimately there is no guarantee in life. There just aren't. And seeking a guarantee is unrealistic.
No, I appreciate that, but I would think that your client is RTF, and RTF is representing the entire community of off-road enthusiasts, or says they are. And so I want to make sure that stands through. And I agree with you. There's no guarantee. I totally appreciate that. But I want to make sure that you would leave an agreement on hand to say it has the best opportunity to survive in a court case at the end of the day. And we all want to make sure that type of, and Joe, by the way, I appreciate that information about the letter. I had not heard that. So thank you very much for that. Again, everybody's on board for this. If there's the ability to put in writing that there is zero intention about this going forward. And Jesse, I appreciate, by the way, one last time, and I'll shut the fuck up at the end of the day, but I so appreciate your research on this. It's tremendously helpful, and I can't thank you enough.
You're very welcome. Anytime, Pierce. Bob Sweeney, your hand is up.
How you doing, Jesse? Hey, thank you very much. Good presentation. Seen it before. But I'm along with Pierce on a couple of the questions there. The grant states in there abandonment of the old road. And how you spoke there. It's abandonment and blocking. Blocking is a gate. What I'm nervous about is we go ahead. I'm for the reroute, but what happens if we get in trouble now with the water board because we've disturbed all this new dirt and we have bad flows going down into the water, and now we have access closed and we cannot go back to the original road? With the abandonment on there, how you explained it, we've lost those rights of driving on the existing road that we have today. That's my questions on that. Because I'd hate for us to get back in with the water board again, especially, we're close to Lahontan over there. But with the grant stating the abandonment of the old road is what makes us nervous.
Yeah, I understand. I'd like to see the language in the grant. Does anybody know? Does it say does it simply say the abandonment of the route, or does it say the abandonment of the RS-247 rights associated with that route? The first one I'm not so concerned
the roadway.
with.
It's the roadway, Jesse,
Yeah.
that once the reroute is put in place, Joe mentioned it a couple meetings ago, and then a meeting I had with them. They plan on going in there the following year and blocking that with rocks and trees and whatever, and rehabbing that area. So then we lost our rights of driving through that when that happens.
Well, only if they haven't been transferred to the new route, which I believe, based on what Joe has said, it sounds like that's the intent of the Forest Service. But I'd like to, if Joe was here, but I mean, I can certainly speak to Ken and John afterward and maybe set up a conversation with the Forest Service, perhaps Placer County. I'm happy if there's uncertainty. I'm happy to provide some. I get no impression, at least from Joe's presentation, that there is an intent to interfere with the route, the validity of the RS-2477 right-of-way or anything. But perhaps, just a conversation could greatly ease some of this concern. So I'm happy to provide that or participate in such a conversation, Bob. But I'm not concerned. As I said, moving it from point A to point B, because point A is no longer viable, that tracks very well with that Western Aggregates case that I cited.
Yes,
Okay.
I follow that. I do understand that. I'm nervous I move dirt for a living. I know what's going to happen there, and I know where we were before, as you know, with the water board.
Yeah.
And now we've stirred up more dirt, new dirt, and we don't necessarily have the rights because it is under the Forest Service, and we know what happens. I mean, I've talked with Joe. I know where we're at. I'm with Pierce and everybody else with the reroute. I understand why. I just hate seeing us lose the old road. If we're going to lose the old road, let's not human close it. Let's let natural habitat close, the slide. Let it happen. Let Mother Nature do what it needs to do. Let's not us go close it and then we lose our full rights. Just like the other bypasses that's been done in El Dorado County. We still can access those if need to be.
Okay.
That's the nice thing about the reroutes that have been done on the El Dorado County side.
Not true, Bob.
We still can access those.
If I may interject, just a little information. So yeah, in the grant, we said we abandoned the old route as a driving route, and we direct traffic onto the reroute. Yeah, we're not, but well, the new reroute is designed to be sustainable, and it's actually going to be much better, more stable, more sustainable than the current route environmentally, and obviously with the landslide viability wise. But I'm sorry, I just lost my train of thought. We also specifically said that we would not obliterate the route, so it will still be on the ground. And if for some reason, unforeseen, crazy reason, we needed to go back to it and it hadn't slid away, I mean, that could be an option. But I think the new route is going to be much more stable. The waterboard stuff in the past was human waste issue. We are going to improve the situation with the reroute in terms of sedimentation, environmental concerns. So those are just some of our thoughts.
Well, I'm nervous too, Bob. You know, as a lawyer, I'm always nervous. People pay me to be nervous. You know, people never call me when things work out. People always call me when things hit the fan, you know. So I understand your concerns, you know, and I'm happy to talk to whoever is willing to talk to me to make sure that this works for everybody, you know, because I love the trail as well. I'd hate to see it lost over a miscommunication. So if there's anything I can do to help, I'd certainly put my name in the hat. We've got a lot of people putting their hands up. I see Tyler. It looks like Tyler is next.
Well, Jesse,
go ahead,
thank you
Bob.
very much.
Yeah, go
We
ahead.
appreciate it. Okay.
Yeah.
It sounds like you need to read the grant that was gone out there. It sounds like you might not have read it.
Yeah.
So-
And you know, another thing, Bob, is a grant is not necessary. You know, a grant is a grant of money. You know, I'm more concerned with the actions that people take afterward. You know, a grant, you know, isn't going to be looked at as a grant isn't a quiet title document. A grant isn't is not a formal abandonment of any route. A grant is you know, we want you to do these things to get this money. And so I'm happy to take a look at it, but by itself, you know, the grant is not the end all. Okay. That's
I
not the
hope
legal
not.
document. Yeah,
Thank you, sir.
you bet.
Thank you, Joe.
Yeah, thanks, Jesse, for all this. I guess I'm asking for a confirmation of clarification. It sounds like there's two different types of abandonment possibly potentially going on here, and I wonder if people are getting them mixed up or confused. It sounds like there is with this grant going through, Tahoe National Forest would be taking over the abandoned route by Placer, quote unquote, in terms of the property, but not, it wouldn't classify the rights usage as an abandonment. It's just the route abandonment, and the rights usage would maintain unchanged. Is that, for the most part, as clear, or does it need to be explicitly written in the grant that the rights abandonment is unchanging as well, or anything like that?
Well, it sounds like the grant's already written. And like I was just telling Bob, I'm not terribly concerned with what's in the grant. The grant isn't a legal document. The grant is a contract. The grant, you know, does not constitute a quiet title action. The grant does not constitute a formal abandonment of the local regulating authority or the local supervising authority, which would be the county. You are correct, Tyler, that we are talking about different types of abandonment. And in my presentation, my PowerPoint, what I wrote was formal abandonment. And that is what John addressed earlier, John Arns addressed earlier. I mean, in order for a county to formally abandon a road, there has to be a public hearing. There has to be a public process associated with formally abandoning a public route. And that is what I meant by abandonment. And, you know, if that's what's going to occur here, then, you know, I'd like to get involved, but simply abandoning travel over a particular route and replacing it, you know, with, rather than, you know, segment A, we move to segment B because segment A is no longer viable. You know, I think that as I said numerous times, I think that fits well with the Western Ag case. But I'm happy if there is consternation or concern about that. I'm happy to work with folks and make that much clearer, because I'm not getting a feeling from either the Forest Service or the county that is their intent. And perhaps there's some simple conversations that could be had to address this concern. I'm hopeful. So did that answer your question, Tyler? The short answer to your question is yes. We're talking about two different types of abandonment.
Yes, thank you. That does help. Thanks, Jesse.
There's somebody else with their hand up. I can't tell who's, is it you, John, or?
Yeah, it is.
Oh, okay. All right, go ahead.
So I have a couple of points to make. First, this reroute is a parallel route to the route that currently exists. And we're not moving, as Jesse said, we're not suggesting moving the rights. We're suggesting moving or removing the rights. We're suggesting moving the route. El Dorado County did this between the S-turn east of Ellis for about 200 yards in 2012. There was no, there's virtually no difference between the two. So this has been done before. It's been done by El Dorado County. And actually, if you go back in the history of the Rubicon Trail, it's happened many, many times in many, many areas. I'm just bringing up the most recent one that I was there to witness and know specifically about. So that's one point. The point is this happens all the time. It's happened many times on the Rubicon Trail, and in this case, it's happened most recently in El Dorado County in 2012. And it is what it is. The second point I'd like to make, and maybe you can correct me if I'm wrong, Jesse, but I think the most RTF's opinion is that the most viable thing that could happen would be if the Placer County, and I'm not saying this, I'll preface this. We've worked extensively, RTF has worked extensively with the Tahoe National Forest and some with the Lake Tahoe Basin Management Unit. We've had a good relationship with them, and we've worked hard with FOTR to affect positive change on that segment of trail where they're the fee holder and now the manager. That being said, RTF would be more sanguine if the section of trail between the county line and Tahoma were under more local control, because we think that even if Joe Chavez and Teeny Hood and the district ranger and the forest supervisor all have given us assertions and have been reliable with those assertions in the past that it's going to be open, that I personally am concerned that at some point there will be another federal lands policy management act or another travel management from the federal government that they don't have any control over, or they're retired and I'm gone, and this could happen in the future. I think, and RTF believes that the very best thing that could happen would be if Placer County asserted their RS2477 right in a resolution, and RTF has been working we have been working diligently towards making that happen, and we're working on it concurrently. So the public shouldn't be the Wheeling public shouldn't be is not wrong to be concerned, and I'm not raising any flags or saying the sky is falling. The Wheeling public is not wrong to be concerned, and we should all be working toward an RS2477 public road declaration from Placer County, and that would be the best way to secure the trail locally. And I think we have better control over local agencies than we do over the federal government. Somebody in Washington can, a liberal Congress or somebody in Washington, a liberal Congress can make a congressional act, or a administrator in Washington can affect a policy change that can reach us without them even knowing it did. So that's my spiel.
Thank you, John. No, I agree entirely. It'd be incredibly helpful if we had, got some input and some cooperation from Placer County, where they explicitly asserted their RS2477 rights over the Rubicon Trail that travels through their county. That'd be very helpful. And if there's one thing that this group wants to do, I would strongly encourage your the folks on this teams to contact your representatives at Placer County, and I'm happy to go there and talk to them. I've made the offer before. I'm happy to drive up there and take them out to lunch or whatever it takes to get the county to formally acknowledge and accept that Rubicon Trail is an RS2477 right-of-way road through there, and they could do it now because the road was there. The road was there 1880, when El Dorado County accepted it. So, the fact that that RS2477 was repealed in 1976, you can still accept it. You can see it's still there. It was present. The repeal of RS2477 did not repeal prior existing rights, and that's what we're talking about. It's simply a recognition of a prior existing right.
I see Doug's hand up.
Yeah, I was gonna say, awesome. Thanks, John. Was there more to that, or can we move on to Doug?
Yes, please, Doug. Doug.
So little history, but before my time, Bob might remember this, but 100-mile-an-hour meadow used to go through a meadow below Sourdough Hill, and that got rerouted. I want to guess in the early 80s, but again, that was before my time on the trail. So part of the reroute is going to go away from not even the original route because we lost the original route out of the meadow. So it's happened before, right in that very same area, as long as we got access. I'd like to get with Bob and say, I would like to see the reroute happen because I think we're going to need it sooner or later, but I'd love to see the original trail stay open as long as nature allows it to be open. And when nature says it's done, I get that. But until then, do the reroute, but keep the original open if guys want to go there. So that's what I got.
Joe, if you're still on here, can you address why that's a concern for the forest?
Yeah, we did ask the district ranger about that because of the request from this group, and the response that we got back from Mr. Jonathan Cook Fisher was that because of the known possibility of the landslide, and at this point, with that very steep wall and the narrow path, if a Jeep happened to trigger the landslide and someone, God forbid, die in that, it's like we knew there was a risk and we let it continue. So that's why he, at this point, is not interested in once we have a reroute in place to continue that access.
Lost you, Joe.
Yeah.
Yeah.
I think he was done with his comment there.
Yeah.
The point being is that they know there's a risk there, so if they do nothing, they're now liable if something does happen.
Yeah.
Okay, this is Bob Sweeney. You guys, we're on a off-road, four-wheel drive road. There's liability all over the goddamn place. We don't bring that up in here. That's stupid that the Forest Service is saying that. We have liability left and right as we drive up and down that road, guys. So you can't say liability. That is crazy.
Well, we already acknowledged it in the grant very clearly. So, this is different than just having a route out there that people choose to run. We're saying that this could be triggered by a vehicle, and so it raises the bar, at least in our minds. Maybe the lawyer would have some input on that.
Yeah, I think the question comes down to controlled risk versus uncontrolled risk, is how I would personally envision it. When we're going out on the Rubicon or Fordyce or any of these routes that are big time wheeling routes, we understand that risk that we're taking, and we can do what we can to control those risks. I think that if there's an immediate danger, quote unquote, of a landslide happening, that could trigger. I think that's an uncontrolled risk that could be controlled, but that would not be controlled, and therefore that's where the liability would come in. From my understanding of the situation, I could definitely be wrong. Joe, you can correct me if I am wrong, but that's how I read into the dangers and risk of that reroute area.
I think it's a good summary.
I did have a question. Sorry, I think my hand was next, and then we've got. Oh no, mine's the other one. I forgot what it was now. Jesse, in your presentation, you said that if there was a physical structure erected to block off the route from 12 years, that would constitute another quote unquote abandonment or termination of the route.
Yeah.
Is boulders and rocks constituted as a physical structure erected to block a route, or would it need to be a man-made structure like a gate per se?
No, again, if there is no intent if there's no recognition of the rights and the route is blocked. So the case I'm thinking of, I didn't cite the case, but what happened in the case, the reason why I brought that up was, I think it was in Colorado. There was a gentleman, he had 2 routes into a landlocked parcel, and at one point the Park Service blocked one of the routes with a gate, and that was the RS2477 route. And what he ended up doing is, rather than trying to go through the gate, he ended up using his other public route, which was not an RS2477. And after a period of years, he waited, I don't know, 15, 20 years. And he went in and he tried to quiet title to the 2477 route. And the court said, you waited too long. You had 12 years to claim that you had the rights to this particular route, but instead you went on the public road, and there was no recognition that this public road was going to be the new RS2477 route. So you lost the 2477 route after 12 years. But, you have to be really careful when you apply these facts. These facts are very different from what we are discussing here today. What we're discussing is a reroute of an RS2477 existing right-of-way in a new location to address some sensitivity concerns. That's it. We're not talking about a whole new route that the RS2477 route in that case, he was going from point A to point B. And then the route that he was using instead was to go to point C to point B. He had a different beginning, the same end, but a different beginning. And the court said, well, this is a completely different route. It's not a replacement. It's a completely different direction, and the two have nothing in common. And so the court refused to, and he made no effort in the case, at least the way it was reported. That particular landowner, he made no effort to assert that at least a convincing one, that the 2477 route had been moved to the public road. But it just didn't make any sense. And so you have to be really careful. Again, I told Kent I was reluctant to do this because I am very concerned that people are going to take things way too literal in this presentation. And it's going to happen. I know it's going to happen. And I'll get some calls, but you have to be very, very careful about the application of one specific set of facts and trying to twist them and get them to apply to another. This situation is very different from that 12-year example that I provided, where the guy had two completely different routes to get to his property. We're talking about a reroute. Reroute is more appropriately analyzed under the Western Ag case and its progeny than the case where the guy started at you know, rather than starting at Marysville, he started in Vacaville to get to the same location. Very different route, different roads. I mean, you can think of using highway, right? A good example, Highway 50 or Highway 80. They'll both get you to Lake Tahoe. But does one necessarily replace the other? No, they're just two entirely different routes. And that's what the court was analyzing. You know, if you block off Highway 50, all right, well, you still got Route 80. But Route 80 doesn't become Route 50. It's always been Route 80. I don't know if that helps or not, Tyler, but it makes sense to me. Maybe in my twisted profession, it makes sense to me.
Yeah, no, that makes sense. It definitely, it really just comes down to the claims of the rights. So in a reroute, the claims of the rights transfer with the reroute. So I'm just trying to address exactly the points that Doug and Bob were bringing up of, you know, we lose the original route if we reroute. To Bob's point, you know, if the reroute for some reason something happens, water board comes down on us, whatever, the reroute closes, do we no longer have access to the original route anymore? And I think that the answer to that would be it all depends on where the rights get transferred to with this another reroute or whatever happens. Correct?
Yeah. I'd like to see the language. Whatever, I'd like to see whatever action Placer County takes. I'd like to be involved. And I have discussed this with Ken and John. So
cool.
And just from the Forest Service perspective, if, like I said, if for some crazy unforeseen reason the new reroute is deemed like a problem and can't use it, then the Forest Service would go back and open up the existing route and have to we'd have to do something different, because by that time I'm sure the landslide would have happened, and we'd probably have to do NEPA and find another way around. But I'm sure that's not going to happen, because the reroute's going to be good. It's going to be stable. RTF's going to help ensure that.
Awesome. Are there any more questions for Jesse before we kind of adjourn this and head on out for the evening? All right. Thank you, everybody, for coming. We do have this meeting recorded, as I talked about earlier, so I will get the meeting notes and the recording out to everybody within the next couple of days here, as well as invite for next month. And then if somebody could just keep me in the loop on the Rubicon Oversight Committee, if that is opening back up, I would love to see that succeed. So just keep me in the loop, and that way we don't have to be double dipping on our time here for everybody's time each week. So yeah, I think that does it. If there's not any more questions for me, I'll stay on for a couple minutes. Otherwise, we can head out. Everybody have a great evening. Thank you very, very much, Jesse, for coming on and doing that presentation. It was incredibly helpful.
Everybody is very welcome, and I'll come back if there are more questions. And it was nice to see a lot of familiar faces and names here. So everybody's very welcome, and I am available if you have follow-up questions. So thank you, everybody. We got somebody, Luke. Is that for me or?
Hey, everybody. I just wanted to let anyone know that if they wanted to look at the grant application, everyone's initial grant applications are available to see via the OHV Parks website. Under the grants page, you have to do a little navigating around, but you can find any of the grant applications put in by any of the agencies. And I was able to
Luke, navigating, you're being kind. You mean gymnastics.
Yeah, if you jump around, you can find it. And also all the public comments are available for grants as well. Other people. Comments, I won't leave a comment other than that. But everyone can look it up for themselves if they like to see what the actual grant application verbiage is.
Ken, do you have that saved somewhere, the grant application? Sounds like you have familiarity with the OHV website. Yeah. Okay. I will I will hunt it down, find it, and I will include the link for everybody in the meeting notes.
I'll send you the link, Tyler. I've got it bookmarked.
Awesome. Awesome. Thank you, John.
I have a question
you,
for
everybody.
Luke. This is Joe. I have a question for Luke. Will the final applications be available to the public? And if so, when would that happen?
They should be available, I believe. As far as timelines, I'd have to talk to Jen Grady about that. I'm still new here and figuring out the whole processes myself.
Okay, because there's more information added since the preliminary, obviously, and some response to comments.
Cool. Thank you very much, everybody, for attending tonight. And yeah, if you guys have questions, shoot them my way. I'll see if I can direct them to the right people or reach out to those people individually.
Okay. Thank you all. Bye.
Thanks, everybody.
Thanks, Tyler. Thanks, everyone.